Good morning, fellow Malaysians. This is Matthias Chang once again from Future Fast Forward. It's been quite some time since I last talked to you, and there's a reason. Because I felt that there was no need for me to make another video unless there are compelling reasons. Sad to say, I've decided to address all of you on a very important issue. And it gives me no pleasure to say what I have to say because I'm compelled to do so. After exhausting every means, direct and indirect, to convey to all the relevant people who has a say on the issues which I intend to reveal in due course. I've often said to all of you, it's very difficult to tell truth to power. Why? Because power itself is a very negative issue. It's a very negative trait to have. Why? Because many times I said to you that power corrupts. And absolute power corrupts absolutely. And power feeds on anything that sustains it. Power feeds on lies. It sustains power. But seldom does power feed on truth. It only feeds on truth if it is convenient. Bear that in mind. Power only feeds on truth if it is convenient. Otherwise, power often feeds on lies to sustain itself, and for those who will power, to hold on to power. And I've been trying to tell truth to power since nudging into power. You have to listen. And I have in my previous video said that the Najib regime, before it's toppled, was surrounded by loyal but not smart little Napoleons. Now, Pakatan Harapan government is surrounded by overrated but underemployed little Napoleons. Hence, truth is not getting through. Very unfortunate. Very unfortunate. Now, having said that, I will come to the meat, the substance of my address this morning. It relates to the arrest and seizure of the yacht Equanimity, allegedly owned by Joe Low, but officially registered in the name of Equanimity Cayman Limited. It pains me to say what I have to say or to reveal what I have to reveal. And I hope I'm wrong. I hope I'm wrong. Because if I'm right, shit will hit the ceiling fan. I've always fought before the election with one solid focused aim to get rid of the Najib regime, the evil, the criminality, and the kleptocrats within the regime, so that hopefully, and God willing, on assuming new responsibilities and duties, the new government will make changes. We have been assured many times that if we take action against the regime, the evil, the criminals, we will do so based on absolute truth. We will hold on to the righteous principles of truth, justice, and transparency. We will not cut corners. We will not do so out of vengeance or gloat prematurely of whatever victory we hope to achieve. Pursuing criminals does not give us any victory. Justice demands that criminals be brought to justice. Any victory, if any, is pyrrhic. What is important is truth. The ugly truth to be exposed to our people, so that we can learn from the negative examples by the criminals and then move forward and turn our backs on evil. Now, in support of the action for future, all right, there is a writ filed in court. This is a cover page, right? This is a cover page of the writ filed in court. And there is a very short statement to support the claim by the plaintiffs, comprising of 3 1MDB companies and the government of Malaysia. The concise statement in legal terminology is the general endorsement of claim, okay, which is required in the writ. A general endorsement of the claim by the plaintiffs, as opposed to a full statement of claim by the plaintiffs against the defendant. Okay? All right? Now, and then there is an affidavit signed by Siti Rahayu binti Muhammad Mumozaini in support of the writ and the precipitate application for a warrant of arrest of the yacht Equanimity. Alright? Okay. Now this whole writ relies on one essential document, evidence in support. That is the DOJ claim filed, alright, in the California court. Okay? And that claim, okay, is the exhibit annexed to the affidavit. This is the cover page of the exhibit annexed to the affidavit, okay? And the exhibit is marked as RM1, okay? The exhibit is marked as RM1, okay? The exhibit starts from page 68, okay? 68 onwards, all right? Which is the search with regard to the ownership of the yacht Equanimity. But the evidence, the substantive evidence or document in support of the affidavit starts from page 75, because the last page of the search is 74, the search. Okay? So the court document from USA starts on page 75. All I need to show to you, okay, is the cover page of the exhibit. The DOJ claim filed in the California court. Now at the bottom, you'll notice it states, United States of America plaintiff versus certain rights to and interest in shares of Series D preferred stock. Sorry. I think it's this one. Yeah. Certain United States of America plaintiff, certain rights and interest in the Viceroy Hotel Group. You got it? The defendant is the interest in the Viceroy Hotel Group. Verify complaint for forfeiture in rem. Keyword is forfeiture in rem. Okay? This is American right proceedings. You follow me? Now, the plaintiff, Attorney General Chambers, Tommy Thomas AG, and the firm of solicitors in filing those claims rely on this particular specific legal document. Rights to and interest in the Viceroy Hotel Group. But what we are aiming for is to arrest and seize Equanimity. One would have thought, as a matter of procedure and being meticulous, that the exhibit that ought to be exhibited to the affidavit is not a process or a forfeiture proceeding of another asset, the hotel group. The correct legal document or the writ of forfeiture action must be this. United States of America against all right and title to the yacht MY Equanimity. Verified for complaint for forfeiture in rem. Alright? Now in this suit in America, right, and all the other interlocutory proceedings refers to the equanimity yacht. So that if you refer to some other suit, you may miss out a lot of things and may not make full disclosure of what happened in the suit. Okay? Here it says here, the United States of America bring this complaint against the above captioned asset, that means the yacht Equanimity, and alleges as follows. The plaintiff is the United States of America. The defendant in this action is all right and title to the yacht MY Equanimity, hereinafter referred to as the defendant asset, more particularly described in attachment A. The persons and entities whose interests may be affected by this action are FEP Cayman Limited, Low Tech Joe, the Equanimity Holdings Cayman Limited. Okay? So, there in that suit, okay, DOJ says who are the people who will have interest in the yacht. And name variant in that suit is Joe Low. But you will notice our suit in Malaysia confines itself only to pemilik kapal atau vessel Equanimity Rasmi 101-2086 dari Cayman Island. No reference at all to anybody else who may have an interest or rights in the yacht Equanimity. Alright? As the way is pleaded in the American proceedings in the California court. So the first point I say to all of you, and I subject to be corrected, lawyers and judges, please listen carefully. If you're presiding over this case, have you been misled or given wrong evidence in support of the application for arrest of the yacht Equanimity? Because in the affidavit, in reference to that suit, Viceroy Hotel Groups, although there were paragraphs in reference to Equanimity, there were other documents in the actual Equanimity suit that ought to be disclosed to the court. Alright? So, what is important is, right, if the court had full disclosure of all facts disclosed in the Equanimity proceedings in California as opposed to the Viceroy Group of hotels. You see two, eh? What is on the hotel assets? What is on the yacht? Okay? The proceedings there, right, may have some overlap, but you must look at the proceedings in America on the yacht Equanimity. And we must disclose all what happened in America, which is critical for the judge in Malaysia who haven't got a foggiest idea what's happening in America, obviously, unless the rightful and the correct documents are brought before her or him. All right. Having said that, okay, let me now turn to you. Okay. Now, there are, to many people in Malaysia, even to judges and lawyers, I can assure you, all of you is only aware of maybe thinking, there's only one suit for America. under the title, Innocence of America against Wolf of Wall Street, the famous film that came out 2 years ago. Everybody was screaming, Riza Aziz, Wolf of Wall Street, and the famous actor, you know, what have you. Now we have another suit by the DOJ against the Viceroy of Companies. So at most 2, right? That's why you know as of today. But let me tell you, in total, DOJ has filed 31 forfeiture suits against the assets purchased, laundered from monies of 1MDB. Every asset is a separate suit. Repeat, every asset that was captured, sapu by DOJ, and to be recovered by way of forfeiture is a separate suit. In all, 31. Therefore, matter of professionalism, diligence and discipline, we must bring before the Malaysian court the right proceedings and make full disclosure to the Malaysian court judge what has happened in America, in order for the Malaysian court and the judge to have full control of all the facts to make a equitable, objective decision in accordance to our procedure. Alright? Now, having said that, okay, in the rules of the High Court of Malaysia, 212, right, it says here, okay, Order 70, Rule 4.2, can I read to you, okay? Before a warrant of arrest against any property is issued, the party, meaning MDB, 1MDB and government, intending to issue it, shall procure a search to be made in the caveat book for the purpose of ascertaining whether there is a caveat against arrest in force with respect to that property. A caveat is like land officer. If you have claim to a property, a land, a factory, a house, if you want to stop anybody from selling it or buying, you put a caveat. A caveat is a warning. Right? There is a claim already on that property, on that factory, on that house. So before you issue a warrant of arrest, as per our law in Malaysia, the plaintiffs, 1MDB and Kerajaan Malaysia, through the laws, must make a search in the caveat book at the High Court Registry. And that search must be disclosed in the affidavit. I beg to be corrected. In reading an affidavit, I have not come any paragraph to say that such a search for a caveat has been disclosed. And the search is mandatory. It says here, the party intending to issue it shall procure a search. Shall, as opposed to may. In English technical jargon, shall means must. Mandatory, have to, not may. Okay. Now, having said that, now, in the Equanimity suit, right, we must also disclose that there is a warrant of arrest of the ship issued by the court. Okay? Already issued by the court. And here is a sample of the court's proceedings. A warrant of arrest has been issued to DOJ. Alright? Okay. Very important, huh? Let's go step by step. So the court would realize there is a warrant of arrest against the yacht. Now, then what happened when, before the warrant was issued, the alleged owners of the yacht, or those people who had the rights to the yacht, filed a claim to challenge DOJ. Alright? to make a warrant of arrest of the ship. And the claimants stated here, Equanimity Cable Limited, Equanimity Crew Cable Limited, Equanimity Lifestyle Cable Limited, Equanimity Operations and Maintenance Cable Limited. That means, alright, DOJ has to satisfy the court that notwithstanding all these so-called claimants who has a rights and interest in the yacht, they don't have a good case. And therefore, the court gave a warrant of arrest. This fact is important, right, as to who are the potential claimants to the ownership or rights. Because the plaintiff in the writ asked for a declaration as to who is the owner of Equanimity. I'll come to that later. They asked for a declaration. First order. Second relief or order is the right to sell. More that later, right? And then you will notice, right? All this took place some time ago. Okay, some time ago in the last year. Thereafter, you recall, on the 30th of September, a day after our great Najib went to see Trump, and all of you, misled by the opposition parties, right, said, oh, Najib will corrupt and bribe Trump. Najib will corrupt and pay the courts to dismiss the case. Remember, before the trip by Najib to White House, the filth, the defamatory statements made against President Trump, DOJ, and the whole judicial process in America can be bought, sold out, and they curse and curse and curse. But not one word against Najib, you know. Instead of cursing Najib, they curse Trump and DOJ and the system in America. Yet, the day after Najib visit, the court, having satisfied there is enough assets has been sapu already, right, gave an order to commence criminal proceedings. Okay? Here it says here, an order dated 25th October 2017. The stipulation to stay civil forfeiture proceedings is granted. This forfeiture action shall be stayed for all purposes except the filing of timely claims. The government shall file a status report concerning the status of the criminal proceedings every 180 days, with the first such report to be filed no later than March 16, 2018. That means, after the forfeiture proceedings has been stayed, criminal proceedings have been initiated. Understand? Okay, there's now criminal proceedings in America. Very important. I'll explain that later. Then, okay, then on a later date, hold on, March 26, 2018, DOJ filed a very unusual application for a protective order under laws of America. What does it mean? A protective order is unusual in the sense that this is what happens. So let me read to you. Which has not been disclosed to the High Court judge. Okay? The plaintiff, in essence America, hereby submits this motion for protective order under 18 U.S.C. 983J to preserve the MY Equanimity, a 250 million yacht, which is subject to civil forfeiture, of which the court has already issued an arrest warrant in rem. As detailed below, claimants to the Equanimity have kept the Equanimity in a series of foreign locations and frustrated the government efforts to bring asset to the United States, thereby obstructing court arrest in rem. the government hereby moves the court to appoint the government, US government, not the court, as custodian of the equanimity, and all the claimants to tender the equanimity to the government's custody, and that equanimity be brought to the United States and made available for feature. This type of relief is expressly authorized by 18 U.S.C. 983J, which authorized courts to appoint custodians and take any other measure to preserve the availability of the property subject to sale for feature. Meaning, normally, all right, when you have a protective order, the court no longer has custody. In normal rest cases, right, ambulatory case in RAM, the ship is under the jurisdiction of the court or the sheriff. But here, America applied for a protective order. The government of USA has full control of the ship, okay, to prevent any hanky-panky, okay. And then, in that application, it was brought to the court notice that actually the so-called owners of the yacht even agreed to the sale of the yacht. But the only difference is, right, they preferred the sale to take place in Europe as opposed to USA on the grounds that Europe can fetch a better price. But DOJ was able to prove that in fact 45% of the market for super yachts, all right, the big yachts, the rich yachts, are in America. And America, all right, was the best place to keep the yacht. Okay, so this was the application. And there was very detailed, right, which I wouldn't go to here. This was not provided to the court in Malaysia. Okay, then what happens this? There was a declaration by, in support of the application, by Justice McNair. And this is very important. I'll read to you why DOJ applied for a protective order and subsequently the court gave the order. It says here, based on my investigation, Justice McNair, into the equanimity, I've learned the following facts. A. Joe Teck Low sends directives to the equanimity's captain via the mobile messaging application, what WeChat. WeChat is from China, huh? One of Low's directives was to turn off the equanimity's automatic identification system, AIS, as soon as news broke about this action. While vessels may sometimes turn off the AIS to hide themselves when they are in high-risk territories which serious piracy concerns, the equality was not in a high-risk territory when it turned off its AIS right after news broke about its action. After news broke off regarding this action, another directive from Joe Low to the equanimity captain was for the equanimity to avoid the territorial waters of certain jurisdictions, including Australia, Singapore, the US, on the ground that entering these jurisdictions would cause major problems. The captain was told to instead keep the equanimity in other jurisdictions like Vietnam and Cambodia that were deemed safe. Low's directives were complied with. For example, the equanimity AIS was indeed shut off right after news broke of this forfeiture action, and equanimity did indeed avoid the jurisdiction that Low told the captain to avoid. Attached herewith are Exhibit A true and correct copy of the English language translation of a court filing that claims made in South Jakarta District Court in March 2018. Alright? So, this is a critical evidence that actually the yacht is not owned by Equanimity Cayman Limited, or that Joe is not involved. The fact that when Joe gave directions and directives and was complied with, This indicates that Jolo is the kingpin. The Prime Minister, Pakatan Harapan ministers and all the leaders says, right, Jolo, Jolo, Jolo. He's the criminal, he's the one who bought the ship, blah, blah, blah. The man, the puppet, master. Equanimity Cable Limited was only a shell. Alright? So you can lift the veil of incorporation, isn't it? So the question is, right, given this evidence in court of America, and thereafter, given evidence that, having received this evidence, okay, alright, the court gave an order, okay, dated 15th May 2018. This is a very critical evidence before the court. So, how come in the writ in Malaysia, Jolo is not mentioned as a defendant, owner? Because under the procedure and law, if you see a declaration as to who owns the ship or the yacht, and this is the first relief or prayer asked by the plaintiffs, the law requires that any other person who may have a claim of ownership must be made part of the defendants. This fact was made known in my previous video to whole country, to the leaders of Pakatan, before they took power and after. Yet, in this writ, Jolo seems to disappear out of sight. Contrary to the requirement that when you ask for a declaration of ownership and you allege publicly, Prime Minister, Finance Minister, everyone in the Pakatan, alright, set up, say, oh, Jolo, 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 Jolo. Even after the ship was arrested, Jolo, Jolo, Jolo. But Jolo's name is not in the writ. Never mind. So, the order says this, the government moves for an order requiring claimants to turn over the yacht and what equanimity, the rest in this case, and if and when claimants gain custody and control of the yacht. Okay? And so here's the order. Thereby he is ordered by the court. Plaintiff United States of America is appointed custodian of MY Equanimity, so that equanimity may be brought to the United States. Keywords may be brought to the United States. Claimants are required to tender all custody and control of equanimity to the United States, and the parties are to attempt to reach agreement concerning the means by which equanimity will be brought to the United States. In the absence of the agreement to the contrary, the parties are to follow the instructions given by the court. This April 2nd, 2018 order. Okay. This order was served on the Indonesian government, the Ministry of Human Resources and Justice, under MLA, and the Indonesian government, recognizing this order issued by the California court, handed over the yacht to American custody. Very important point. Okay? That was before Prime Minister Tun Mahathir has little TT, right, with Joko, President of Indonesia. Indonesia recognized the jurisdiction and the sovereignty of the United States to have custodian or custody of the yacht. Handed over. See that? This is the order, the stipulation, recognized and implemented by the Indonesian government. So why is there a transfer all of a sudden? In contravention of this order, which is expressly acted upon by the relevant authorities of the Indonesian government. Think about it. The consequences of implications. And in the affidavit, the department says, right, she was responsible, together with the police force, IG whatever, with the Indonesian police force, to arrange to take the yacht out of Indonesian waters of Malaysia. Was she aware of this order? She was not aware because it was not referred to in the affidavit. Because they read the wrong suit, which was exhibit in her affidavit. Okay? Then, when the order was given by the court, okay, the alleged owners of Equanimity apply for a stay. Don't do that yet. We want a stay. The stay was dismissed by the court in California. And then they appeal to the Ninth Circuit Court of Appeal in America, in California. The Court of Appeal dismissed the stay application. Dismissed. That means the order is a perfect order. The protective order. Recognized, implemented in Indonesian waters by the Indonesian government. So you have to ask the question, if you have this order, DOJ, you are supposed to bring this yacht to America for sale, as agreed. And the process will be kept until final determination who is right owner. Why would DOJ and those attorneys involved would have a quiet discussion to allow this to transfer? I beg to suggest the statement that there was a collaboration with the DOJ is incorrect. If there was such a collaboration, alright, with this order, it doesn't make sense, isn't it? They fought so hard. And then, contrary to the statement made by in the affidavit and the Attorney General, in the court proceedings, right? You recall earlier, when there was a stay of the forfeiture proceedings and to allow criminal proceedings to commence, the court ordered, right? DOJ or the defendant must every 180 days inform the court any developments anywhere concerning the yacht. And that's what happened was on the 6th of August, one day before the arrest. Okay, I read to you. If DOJ knew in advance, right, was in cahoots to transfer the yacht to Malaysia, why would this declaration made by John Kusera and Michael Hugh Hoyt, Assistant United States Attorney, Wu S. Liu, Deputy Chief, Money Laundering Unit, okay, says this. This is like DOJ informing California court. The government, the plaintiff, right, has learned that the defendant yacht has been released by the Indonesian government to the government of Malaysia and has left Indonesian waters. It is the government's understanding that a warrant was obtained in Indonesia authorizing the turnover, full stop. So DOJ says, right, it was understanding there was a separate warrant to turn over the yacht from Indonesia to Malaysia. Where was it disclosed in the affidavit? The AG, whoever, or the plaintiff's lawyer has applied a warrant, whatever the warrant is, right? Okay. While the government maintains that the turnover of the defendant yacht to Malaysian authorities has no effect on this case in rem jurisdiction over the defendant, it notes that neither Indonesia nor Malaysia is a party to this action in America. Very important, huh? There is action in America. Why didn't we intervene in the action in America? I have advised, I've shouted down to the powers that be, intervene in America to claim ownership. Because US government has the custody, US government will protect the property. Don't have to worry, we just go there, intervene and claim. But we want to have drama, bravado. Okay? The government proposed that all proceedings in this action be suspended in order to give the government and any interested claimant the opportunity to inquire of Malaysia through formal channels what its intentions are with respect to the different yacht. The government further proposed to report to the court no later than 17th August 2018 on the results of the inquiries. Now, if DOJ is aware of the so-called hush-hush secret negotiation which Agent Tommy Thomas disclosed, right? Why should this notice? Court document, right? Says that, right? They, the US government, and any other person interested will have to go through official channels to Malaysia to find out what the hell are they going, what's going on, what they're going to do about the ship, and report to the court. So this statement was issued 6 August, a day before arrest, the day in which these people, AG and the plaintiff's lawyer, led by Sippa Salvaranam, was in court. So there is now a contradiction in it. What's stated in the affidavit and what transpired. These are attorneys, right, in charge of the case. Surely, Jeff Sessions, being the Attorney General, would have completed all these things too. Those attorneys, never mind. So this would happen, okay? So, and then the defendants, the alleged owners, also give a notice to the court as to what actually happened. Right? Whether what they say is true is up to the court to decide later. But my point is this now. There is, this is my whole file. Okay, you see? I flag it there. I have several sets just in case someone robs me or destroy it. Several sets. Okay? So, very clear now. When you depose an affidavit, you tell the truth. Right? Applying for arrest, or whatever arrest, is like applying for injunction. There must be full disclosure. Obviously, there's no full disclosure because the wrong writ in RAM was annexed to the affidavit as exhibit. Viceroy Group of Hotels. Nothing to do with the yacht Equanimity. Now, have they gone to court, California court, like I did, get all the documents from day one till now, then you have all these proceedings, as I flagged them, and so many interlocutory proceedings. I can't explain all to you, okay? No time. But the essential fact is, which I want to tell you is that, right? We exhibited the wrong exhibit, only one. But there are so many exhibits to be exhibited, you see here? All flagged. All very relevant. Now, would the court in Malaysia, given the protective order, the US government, as opposed to the court, would have custody and jurisdiction over the entire yacht? Would it give a warrant of arrest? Knowing that the Indonesian government have already, through an MLA, mutual legal assistance, agreed to the protective order, handed over custody and control to the US government. And then, Indonesian police and our police went on board, took the ship. Is that right? With the greatest respect and humility, it's wrong. And I hope there are lawyers out there, judges, current or retired, will follow up with this disclosure, expose, and advise the government and AG Tommy Thomas. He said, with great pride, in his statement on 9th of August, I'm not questioning the expertise of anyone, but there was some bravado. The real test of Miss Savaratnam experience and expertise will come into play if and when Joe Low or any other party applies to set aside the warrant of arrest. The arguments would then be vigorously put forward by all sides. But the court hears the matter on its merits, and it's critical that Malaysia has the best barristers. Litigation is dynamic, unpredictable events occur in court, and Malaysian case must be in safe hands. With the greatest respect, given this disclosure, and I stand to be corrected, the case is not in safe hands. Far from it, the material non-disclosure. Now, right? You see, the relief in Malaysia, as per the claim, is very simple. I'll read to you. At page 8 of the claim of the writ by Sipat and her team and AG, a declaration that the 1MDB group are the legal and or beneficial owners of the vessel, Equanimity, and or part owners thereof in proportion to their respective shares therein, to the extent of the monies and or property of 1MDB group used by on behalf of the defendant to purchase the vessel from Ocean Co. and order for the sale of the vessel. So the first relief is the declaration of ownership, okay? First relief. What is the law? If you're asking for a declaration, and I refer to a very authoritative book, Atkins, all lawyers know it's very authoritative. I say, read to you at page 29. As to what you must do if you're seeking for a declaration, who should be the defendants? A writ in rem is normally addressed to the owners of the property proceeded against, as stated here. In an action for a declaration of ownership of a ship, all persons other than plaintiffs claiming possession or ownership, or possession and ownership of a ship should be, if possible, be named as defendants. Now, if you're asking for a declaration of ownership, and you know that besides Equanimity, Cayman Limited is registered owner, it's the absolute truth, right? And there are other people claiming that if you have done the search in this court, you will know there were others there. Companies registered in Cayman Island, challenging, alright, as per the court documents I showed you earlier. And Joe Low, which everyone screamed is the mastermind, is the real owner. Why is he not named in the writ as required? And then it's interesting. The writ is what we call a general endorsement. A general endorsement is about 1 or 2 paragraphs, that's all. A short, right, passage as to what is your claim. Okay. Now, in admiralty action, you can sue for ownership, claim ownership, or there's a collision between ships, right, whereby freight is lost, people are damaged. Then the procedure is quite different. Okay, bear in mind, huh? If you're claiming loss or damage as a result of collision, 2 ships, right, as compared to a writ in rem, seizing the ship itself or the yacht, the procedure is as follows, right? The form of endorsement of the claim, here is general endorsement, may be varied to suit particular cases. In cases where preliminary acts are filed, the writ will be generally endorsed. That is endorsed with a concise statement of the claim made or the relief or remedy required. If it's a general endorsement, only a precise statement. Alright? But you must file what we call in law preliminary acts. Preliminary acts is merely a document. Nothing fantastic, right? To say how the collision happened. You can't have a detailed statement of claim at that point in time because collision of ships, spilling, life lost, take a long time to ascertain who is at fault. So there is a requirement to file this document titled Preliminary Acts. Alright? Normally in collision cases. In those situations, you only file a general endorsement of claim. In all other cases, like this case, you must file a full statement of claim. I didn't say it, this is accurate forms. Okay? In the event no one appear or challenge or can't allow this arrest, if you want to apply for judgment default, no judgment default can be issued to the plaintiff unless a full statement of claim is filed. Okay? This is what happened. On that, I will not go further. I just want to tell you that, right? The claim in Malaysia is for a declaration of ownership and order for sale. In page 246, 245, 246, 247, and 248 and 9, okay? The relief by DOJ is different. Alright? From paragraph 942 to 957, is in aid of criminal proceedings. Because it states that relief, because they have committed crimes, we need to preserve this asset as evidence of the crime. For example, right? Okay, I give you an example. First claim for relief. Okay, first claim for relief. Follow me? I just read 1 out of 4. The defendant asset is property that constitutes and is derived from proceeds traceable to one or more violations of 1. A foreign offence involving misappropriation of public funds by and for the benefit of a public official, 18 U.S.C. 956 C7B 4. 2. Fraud by or against a foreign bank, 18 U.S.C. 1956 C7B 3. Third, wire fraud. 4. International transportation of receipt or receipt of stolen or fraudulently obtained property. On and on. Can you see now? The relief is pursuant to specific criminal offense. Okay? Because criminal proceedings has started. You follow me? These are not disclosed. We have not commenced any criminal proceedings. Alright? Why? You know, our IGP recently gave a statement. AG. They never asked for MLA from us. Sorry, you know, we never asked MLA from them. We don't need them. We do our investigation. They didn't allege. They didn't ask. They asked. We didn't give. We didn't agree. AG says, Swiss asked for MLA. US asked for MLA. Therefore, it gives the impression, right, that our enforcement agencies has all the evidence there. Yet in the affidavit, the whole case rests on a wrong suit. But the evidence relied on is from DOJ. Shame! What embarrassment! We tell the whole world, the Prime Minister and other leaders, with almost a perfect case against Najib, almost perfect case. What can you show for your perfect case? No one freaking one MDB prosecution, not even Arul Kanda is in Malaysia and all the other scumbags. While waiting for Najib and Jolo, all the low-hanging fruits, not touched. Investigations keep on going on and on and on and on. And the excuse was last time, you were not in power. This covered up by Najib, blah, 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 by the police, blah, 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 by MACC, blah, 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 by AG, blah, blah, blah. Now you're in power. Now you are in power. What are you doing? Don't give more excuse. And all you have to show is DOJ complaint. And we have the guts and the audacity and the filth to condemn Trump administration, to condemn DOJ. They can be bought. We can't trust them. Even though there is a protective order. Never have you heard of that? The power of the court. Is that done in Malaysia? The yacht must be sailed, delivered by the claimants to America. Is that wonderful? They did all the hard work, and last minute, wow, bravado. We are the heroes. Nay, we are the heroes. We didn't lift the heavy load. We ignore international law. And of course, the greatest respect of President Joko of Indonesia. What is it? Can your word be relied upon? You're given custody to the Indonesian government. You comply with MLA, and then you turn around. You flip-flop. And then what? Oh my God! Start online. Dr. M at Port Klang to inspect Jolo's super yacht Equanimity. Jolo! Jolo is the owner. You said it in public, reported star. Oh my God. Oh, yo. Alright? Now, I was told it was accompanied by IGP, Chief of the Army, Military. By the way, to all my lawyer friends and judges current and retired, and every one of you who have little cases before, right? You will know, is it? Kalau you sudah attach, foreclose, you dapat satu hukuman dah dari court lah, the bailiff attach the house, the factory, okay? Or foreclosure. What happened? The bailiff and your lawyer go to the factory, the house, or office, buat satu inventory, tutup, seal, padlocked. And you, the plaintiff, must provide security guard. No one can enter the office, the hotel, the factory, the house. No one, All the movables, the furniture, the bed, the paintings, everything sealed. No one can enter. But here you have. They're almost the big wigs of Pakatan Harapan government. Guan Eng, PM, the Line, and the enforcement agencies, IGP, right? Why did IGP tell him, you cannot go up? This is evidence of crime in America, in Malaysia. Tak boleh. But he went up there. And then you say, right, after you have been a tourist for a while, you then say, public cannot visit because it may, right, damage the yacht. Right? The court is very clear order. Only the sheriff, if you have the permission of the sheriff to board the yacht, you have no business to go up the yacht. No business. And the law is very clear. If you go on board the yacht without the permission of the sheriff, it can amount to a contempt of court. Ayo, AG, have you advised Prime Minister Mahathir? Don't go near the ship. Has the plaintiff solicitors led by the most expert in admiralty action, said Pa Salvaratnam, then you take the trouble as plaintiff solicitors to advise the head of government, Tun Mahathir, Prime Minister, or the directors of M1MDB. You cannot go near the yacht. It's already seized, sealed. But you don't care. You gave a press statement, all right? More of that later, I can go on and on this issue. Many steps have been infringed, contravened, ignored. My God, what have we come to, this country? That's why I said, you would like it, during Najib regime, loyal but not smart, tak ada otak, gila, angin. Here under your government, I think it's right to describe it as right, overestimated, underemployed. Makna, right? Your talent's over exaggerated lah. Tapi what you do, right? Not full lah. Tak cukup, tak penuh. That's why you're underemployed. Right? Wanking, jerking off. Now, isn't that incredible? There are so many things I want to say. I'm holding back. You know why? Because I have no wish to lose this case. Right? You might say, Matthias, you're hurting the government. And Jolo, no! I was a victim of injustice, abuse of power and procedure. Even if my enemy Najib, Jolo, I will not allow, as a lawyer, as a man of whole justice, that they will suffer any injustice or abuse of process or power. They have not done it to me. Never mind. I fought them. I won. I was acquitted. They're still appealing against my acquittal. Never mind. But I will never allow any government to use the same abuse that I suffered for any other person, even he's the enemy, political enemy. You see what happens? We give assurance, to the people. We will follow the law to the letter. No abuse. So what happens now? I pray I'm wrong. I hope there will be amendments made to this, and they will eat humble pie, and this will quietly forgotten. I'm forced to make this video. Forced! Because of my representation, because I'm so sick and fed up. Right? To tell power the truth, the ugly truth. I ask my friends to do so. Things are not going well. Numbskulls are running around. Overrated, underestimated. They don't know the law, but they told themselves they are the expert, they know the law. But I've shown to you to this extent, things are not right. And maybe we better pray there's a default judgment. And then maybe we don't have to expose all this. Even in default judgment, I'm sure the judge would not allow a judgment entered based on, right, incorrect procedure, non-disclosure of documents. Because in an injunction situation, like Mariva or entered below order, it is non-disclosure of material facts, automatically the injunction is set aside. Even without anyone opposing, the court, knowing this, can on its own volition, set aside. How many more mistakes we make? And I was told the original charge against Najib way back a few weeks ago was wrong and had to be amended. You see? The original charge against Najib, big fanfare, was amended. If you amend a charge, you actually say the original charge is wrong. But the law allows amendment. Inshallah, the court may give face to AG chambers and allows amendments, or a corrective affidavit. But an affidavit cannot improve on the pleadings. The pleadings must be exact and correct. Maybe we have to even amend the endorsement of the writ. Alright? Having said that, I will now therefore reluctantly say to you, okay, see, in American suits, right, they have warrant arrest, right? Warrant arrest in Malaysia and England is also associated with admiralty jurisdiction, high seas, okay? But here I can show to you, in the film Dumb and Dumber, there's a warrant arrest. Okay, I guarantee you. Okay, this case. In the case against the one pair of diamond rings and matching diamond ring, there was also a warrant arrest. Okay. In another suit against oil painting, one oil painting entitled Nature Forte or Grand Deal to rule, also warrant arrest. Another case, in the shares of a company, there's a warrant of arrest. In the Viceroy Group, there's also a warrant arrest. Okay? Now the warrant arrest in America is quite different from the warrant arrest as understood in Malaysia. Even jury, because it's a forfeiture proceedings. It's not an admiralty proceedings, understand? Different. That's why we have to be patient. Do some hard work, research. Now you understand why I took so long to make this video? I had to work my butt out, do my research. Okay? This is entire file, almost entire file of the suit in America concerning equanimity. I can assure you, if AG Chambers, Tommy Thomas, Sipa Samaratnam, and whoever, Jeffrey, whatever, had this in their possession, this will be exhibited to the affidavit. The fact it was not exhibited means they don't have this. So, from the word go, the first step, salah lah. Isn't it embarrassing? Isn't it embarrassing to our country, to our integrity? To those international lawyers, my God, all people claim, they are well versed in international law, international maritime law, blah, 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 blah. Huh? Isn't this concerned international law? When the warrant of arrest and the protective order has been issued, recognized, and implemented and executed by the Indonesian government, and we went ahead and contravened it? Shame. Shame. Now, before I conclude, I just received a statement, horrifying statement. Dr. M admits in closed-door meeting, academic promise without expecting to wait in GE14, start online. Well, he can speak for himself and all the leaders of the then opposition parties. But I can say, on the Quran, on the Bible, I told Tun Mahathir, we will win. And I told Mahathir, stop this nonsense of the book, the manifesto book. Rubbish. Make it simple. A few slogans, few objectives. On the top is Najib, buang Najib. Transform our government after we capture power. Okay? Because the whole country wanted that. They give you Najib, I can tell you, your manifesto has no role to play in winning the election. It's the anger and hatred against Najib. And they want change. And they're giving you a chance to change. Okay? And yet now you confess. You make a manifesto not expected to win. That means you lied to achieve power. As I said in my previous document. Power feeds on lies. So many people who watch my video say, Matthias, you have changed. You're criticizing Mahathir and Pakatan. Why not? When I criticize Najib, you clap. You cheer me on. Because it's wrong. It doesn't mean that when Pakatan Harapan is wrong, I keep my mouth shut. That's hypocrisy. That's cowardice. I'm not loyal. I'm not loyal and not smart. Huh? I owe no loyalty to any individual. I'm loyal to the cause, king and country, and Allah. Nothing else matters. That's why I dare say what I say. Don't get me wrong. I want victory for the people. But the victory must come with total compliance of justice, truth, and a due process of law. Okay? Now, one more thing, because I want to interfere. I was told Dr. Mahathir and the foreign minister, whoever, is going to China for very tough negotiations. Now, I wonder how many of you in the entourage in government really understand Xi Jinping. Because we're going to negotiate with Xi Jinping, right? Well, I assume that you know everything, but just in case you don't know, you got today, Wednesday, Thursday, and Friday to do some homework, okay? I'll give you a clue. Huh? Xi Jinping is a strategist, a student of history. This is what he says. I'm not sure whether you have heard about it, although you have people who have political science, right? Have you heard of Thucydides, the great historian, concerning the Peloponnesian War between Athens and Sparta? Well, that thesis concerned war between Athens and Sparta. The strategy, the thinking, the application transcends all others areas, economics, philosophy, politics, whatever. Okay. Now, this is what he says, Xi Jinping. Maybe you prepare yourself and advise to Mahathir also before you go there, before you make another blunder worse than this. Quote unquote. Xi Jinping, read between the lines as well. We all need to work together to avoid the Thucydides trap. Destructive tensions between an emerging power and established powers. Our aim is to foster a new model of major country relations. Bear in mind, we are now torn between China, South China Sea, America, Pacific, South China Sea, with Deputy Sheriff, Japan. So why would Xi Jinping make a reference to Thucydides trap? Have you heard of him? Okay. Well, I think I better show to you. You better photograph the real Thucydides trap. What's it all about? It's not about war, it's more than war, right? Go and do some research on the history of the Peloponnesian War and what lessons to learn in negotiations on economic warfare. Okay? And the true trap is beclouded by passions like fear, hubris, and honor. Hubris, arrogance. Be careful where you go there, huh? So, maybe I'm too presumptuous, right, to tell you how to prepare your foreign policy and negotiations. But I know for a fact, I don't think I need to stand to be corrected. You guys had no inkling what is on Z's mind. So with that, I thank all of you for your attention and hope you understand my stance all this while. I'm for truth, I'm for victory for the people. But if I see numbskulls, arrogance, hubris, self-interest, abuse of power, I'll step in with no reservations. Okay? And I hope one day you will realize the risks I've taken, the sacrifices I've made in making this video and my previous video. And I therefore urge you, always, surrender your will unconditionally, absolutely to Allah. Have absolute faith that He will protect us, defend us, and guide us under all circumstances in the face of evil, Satan, enemies and adversities, challenges, so that we will actually one day arrive to all the glory of the Promised Land. Inshallah. Thank you.